going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Thursday. Happy Thursday. 1 day left of the work week. Actually, this is my last day of the work week. I am going on a little trip tomorrow. Yay! Anyways, you guys want to watch some court? I want to watch some court. Let's watch some court. I've got a few good ones tonight. This is going to be a little bit of a shorter live. I've got it set to like 38 minutes instead of my usual 55. So, yeah, we're going to finish a little early tonight. I need to get some sleep. I've got a 15-hour drive tomorrow. So, yeah, gotta get some sleep tonight. Anyways, you guys ready? I'm ready. Let's see. What do we have tonight? We're going to start with the video that's kind of been on every channel. The attorney that's being turned into the bar, potentially held in contempt for using AI. Allegedly, we don't know. Kind of sounds like he did, but we'll find out. That's in Judge Tammy's court. Got a good one with Judge Simmons. We get to watch someone go to jail. And then I got a follow-up in a Judge Clark case. And then we finish with, a really weird landlord-tenant case. So that's on the docket tonight. All right. You guys ready? I'm ready. Before I hit that play button, you know what to do. It's someone's birthday? Bill, whose birthday is it? Is it Jedi's birthday? It's Jedi's birthday? Jedi! Happy birthday! Happy birthday, Jedi! That's awesome. Hold on. It is Jedi's birthday. Happy birthday, Jedi. Happy birthday! It's not every day you turn 21. Happy birthday. Yes, I am going to Canada. I'm headed to Canada tomorrow. Well, no, tomorrow I'm not headed to Canada. Tomorrow I'm headed to Maine, and then Saturday morning I'm headed to Canada. I'm not going to do the entire drive in 1 day again. Can't do that, but I'm going to do about 75% of it tomorrow, and then finish the rest of it on Saturday. So that's what I'm doing. But happy birthday, Jedi. Okay, you guys ready? Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right.
I don't remember where that is. Hold on. Yes. The answer is yes, but it might take me a second to find it. Hold on. Oh, you know where I think it is? Yep, I got it. All right, you guys ready? This is loud. This is for Jedi. It's her birthday. All right, that was loud. I know. All right, to the video now. Let's go.
Case on the calendar. Somehow I lost where I was on my calendar. Oh, there we go. Okay, so that was the third case. Fourth case on the calendar is Costin Cruz and Ada Melina Costin Cruz versus Darius Nellums.
Yes, Your Honor, this is Luke Kennedy for the defendants.
And
Right.
Tristan Gillespie for plaintiff.
All right. So, Mr. Gillespie, when we were reviewing your documents, your your motion, some of the cases weren't making sense.
Oh, goodness.
I'm happy to review that and fix whatever needs fixing.
All right, Mr. Kennedy, did you have that issue? Because we were trying to.
I did, Your Honor, and that was something that I wanted to bring up today. So that's part of the reason why I didn't file a reply is because I was starting to look at these cases that were cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. And so, for example, Your Honor, on page 2 of the response brief, the Kaplan versus Banks case, I cannot find any case by that name. And
neither could my staff attorney, and she started to question herself. She's fairly new, and I said, no, you've done this before, so let's just ask questions. So, Mr. Gillespie, none of the cases made sense.
Sure. I'm pulling it up right now, Judge. Bear with me one sec.
And in all fairness, I'm going to tell you, I looked you up, so I know you practice in several jurisdictions. I'm not sure if this is something from another jurisdiction, and maybe it's their case law, but it's not Georgia.
Yeah, no, I have this as the Georgia Court of Appeals case from 2008. The Zoom is sucking the speed out of my computer. Hold on one second. I'm trying to actually pull up the case itself. Hold on.
I'll be back in a.
Oh, Judge just dipped. Oh, this gets so bad for the attorney. This gets so bad. For anyone that's seen this already, no spoilers, please. No spoilers. What do you mean no video?
Well, let's see here. Look at this.
You guys can see this, right? No, yeah, you can. You made a comment about the judge's face.
Okay, and also Roland v. Say. I don't know if I'm pronouncing that properly. Let's see.
Judge isn't back yet, Tristan.
I'm back.
There we go.
Okay.
Hey, Lori, welcome. Welcome to your first live. Welcome. I don't know what else to say. Thank you for being here. Thank you. Words. Sorry, I'm giddy for tomorrow. I've spent all day cleaning and packing, so I'm crashing after this, waking up early and leaving. So I'm if my mind's a little distracted tonight, I apologize.
Well, yeah. So the site I have is Kaplan v. Banks, 289 Georgia Court of Appeals 193. It's a 2008 case. Got some quotes from it. Big one is on page 194. The negligence of an insurer in failing to answer a complaint on behalf of its insured does not constitute providential cause or excusable neglect under OCGA 91155B.
All right, Mr. Kennedy, tell me where you had issues, and then maybe I can tell you where I did.
As far as the citations go?
Yeah, because the case law, like I said, I wasn't, some of it just wasn't adding up, or I wasn't able to find the sites that were listed.
So that first one, that Kaplan v. Banks, was the first one that I noted that I just couldn't find either a case by that name or that citation to the Georgia Court of Appeals went to a different case called Hightower versus Cervantes, which analyzed the timeliness of an appeal and had nothing to do with what it was cited for in the brief. The Roland versus Say case right after that, 213, it's cited as 213 Georgia App 679. My note on that was that it doesn't talk about anything that was in the Penn site in the brief. It was about abuse of discretion in allowing a defendant to withdraw admissions, and that an occupant of a trailer assumed the risk of injury by walking over a defective floorboard. Nothing about an insurer or agent, not a valid ground to open default. The Henderson versus Quadramed Corp case, I actually cited in my brief for, I think, pretty much the opposite of what it was cited for in plaintiff's response brief. Collier versus State Farm Insurance Company. I did find a case by that name, however, not at the site that was listed in the brief. It was not at 248 Georgia App 264. However, the Collier versus State Farm case was just an insurance contract interpretation. It didn't have anything to do with an answer deadline or resetting the clock, as was cited in the brief. And then the last one I noted was Somerville versus Innovated Images LLC, which was cited by plaintiff and has actually been overturned by Bowen versus Savoy, Georgia, which is 308 Georgia 204 in 2020, which was pointed out in my brief. And Your Honor, I would just also say the timing of the filing would kind of raise some red flags for me as well. And you can, I'm hesitant, I don't want to cast aspersions, but I've seen this has started to become a pattern where the responses to my motions get filed within an hour or two. And I'll just go ahead and tell you, this isn't before you at the moment, but I did file a motion for summary judgment. And that response brief, I was noticing some of the same things. And I know Mr. Gillespie he's been suspended from practicing in Maryland before. And again, I'm not trying to cast aspersion, I'm just telling you facts. So he's been suspended in Maryland, and part of that was for lack of
Hold
candor.
on, where is he?
It appears that he either dropped off the Zoom call or lost internet connection, Judge.
I think he's coming back on. Hold on, let me see.
Okay.
Yeah. Mr. Gillespie?
This is a good time for a break real quick. Vic, thank you so much for your super chat. I appreciate it. Was Mary Smith a bit late? Fine paid. Thank you, Vic. I do appreciate it. And I'm sure Mary appreciates it too. Thank you. Yeah, he does come back. He claims his internet's messed up. I think, he had to wipe some sweat from his brow real quick. I think that's what he was doing.
Sorry, I got knocked out. I think I'm using too much of my computer's bandwidth or something right now.
So, Mr.
Please.
Gillespie, I'm a former
Yeah.
staff attorney for 2 Superior Court judges. So, and the staff attorneys I'm privileged to work with are really, really thorough, and we check
Okay.
everything. And so my concerns are that not just that we've had some very well-publicized cases where I guess ChatGPT or whatever the legal version of the AI, research and writing platform is, but we've had some issues with that where even judges have been dinged because they've, instead of using good old elbow grease and eye shine, they've, resorted to using the platforms. And what concerns me is you're in about 30 different jurisdictions, I swear, between the federal court, 5 different states. I'm a second generation lawyer. I practice in one state because it's easier. You get to know everything. You don't mess up. I had to discourage my uncle, who's a lawyer, from practicing in federal court. I was like, the timing's different. You're old school. You got to practice where you know and where you can be proficient at all of the rules. And so my issue has always been attorneys need to know the rules of where they practice.
Oh, absolutely. That you're right. AI, ChatGPT, it's a great tool, but that's what it is. It's a tool. When you start using a tool as a crutch, yeah, that's when stuff like this happens. You just got to know the difference between using it to clean something up or help you with some kind of minimal task, and writing a response to a complaint. Like, yeah, there's a big difference there. Again, tool versus crutch. And I know crutches are technically tools. I know, but I think you guys get what I'm saying.
And be proficient in that. And it's hard to do when you're in 5 different states, 27 jurisdictions in the federal court. So what I'm saying is, just listen to me.
Yep.
you risk a reputation, and as lawyers, that's really all we have is our good name and our reputation when you are trying to do too much. And so this brief concerns me because your client is owed a duty of representation, and you owe a duty to be true to the rules of the bar when you raise your hand and swear the oath. And I just need to know what's going on.
Totally understand. And I don't know how to move forward from this other than happy to provide additional briefing, copies of the cited cases, whatever.
Well, I trust
Your Honor
that
would like.
Mr. Kennedy went to a law school, if not the same one I went to. I trust that my staff attorney went to a law school, and reading, research, and writing is the first thing you learn. So if two lawyers are telling me that they've had issues, then additional briefing is probably not going to help.
Understood.
I need some kind of understanding of what we're dealing with.
Okay. Well, very good.
He doesn't want to admit it. He doesn't want to admit that he used AI to do this. He knows better than to admit it, so he's trying to just talk in circles to hopefully get some time, is what he wants. Sparkle Poots, thank you so much for the super chat. Happy birthday, Jedi. Whoop. Happy birthday. Thank you, Sparkle Boots.
Then, should we? How would you propose we proceed?
Mr. Kennedy, this is also your client's case. Talk to me.
Yeah, Your Honor, I was mulling kind of what to do about it and what to ask for. And again, some of the stuff is going to relate to the summary judgment motion, which is not necessarily before you at this point in time. I would at least ask for my client's fees to be reimbursed for having to be here and respond to the motion or the response brief itself, which I don't have that number right in front of me, but I'm happy to supply an affidavit of what that is. Beyond that, I'm not sure if I don't want plaintiff herself to be penalized, so I just want to put that out there. I don't think she should be penalized because I don't necessarily think she has anything to do with this necessarily. It is more.
Well, the brief would, as I understand the statutes, the brief would constitute direct contumacious behavior before the court, which would result in a contempt finding. I wouldn't have to do much extra because it was presented to the court, and the contumacious behavior is written in written form before the court. So I would definitely.
Is that how you say that word? I thought it was contemptuous. Are they two different words? Yeah. Look at Moose. Are they two different words? Contumacious, contemptuous. I need the answer to that question. I need the answer to it.
Always back myself up and look again at the statutes before I make a decision, especially on a contempt. But I do believe that in this case, sanctions are warranted, and especially attorney's fees. So go ahead and present your affidavit, and then we'll make a decision on what's to be granted. But Mr. Gillespie, I say this, and I've said this, like literally my family's replete with lawyers. My brother's a lawyer, my mama's a lawyer, my uncle's a lawyer, I'm a lawyer. The one thing that's been drilled into me my whole life is in the practice of law, it's the only thing you have is your good name. And when you're trying to do too much is when you usually risk losing that. And I get trying to practice in a lot of different areas and do a lot of different things, but it is hard to be excellent when you do that. And so I have a concern, and I feel that as it is my responsibility, I probably will have to share this with the bar. And so there may be consequences that result from that.
Understood.
All right. All right. So what we're going to do is continue this hearing. We'll give you a date certain for the rest of the hearing. Mr. Kennedy, go ahead, and maybe by that time, the summary judgment motion will have caught up with the court. Mr. Kennedy, go ahead and present your request for attorney's fees and sanctions, and the court will consider that as well as any further action I have to take. But Mr. Gillespie, I just judges talk, and so if you practice in multiple jurisdictions, the word will spread. And so I just caution you to be mindful of that.
Thank you.
All right.
So, Your Honor, just to make sure I'm understanding, so we're just going to set another hearing where we'll take up the rest of this motion as well as probably the summary judgment. And I know plaintiff filed a motion to withdraw deemed admissions, from RFAs.
I got it. I reviewed it.
Okay, and I know that's not right, but either. So we just want to take all that up at one time down the road.
Yes, please. And I'll set you all separately.
Okay.
Miss Powell, if you could just give me a date, maybe, some time out, and when we get the summary judgment motion, and then let's hear this case separate from any others.
Yes, ma'am.
All right. Thank you.
May we be excused, Your Honor?
Yes, you may.
All right, thank you.
Thank you.
Thank you.
I don't know how I would feel right now if I was that attorney. I mean, you were what did he say? He was suspended in Maryland. Now he's in Georgia, pulling things like this. I don't know. I don't know. It's kind of hard. I don't know why. It's hard to watch for me because I feel all the anxiety in that room right now. You know what? Let's move on. Cheshire Cat, happy birthday, Jedi. I shall behave tonight. Thank you, Cheshire Cat. I appreciate it. Chris, thank you so much. Happy birthday, Ugg. City's burning in the wake of the candles on your cake. Happy birthday, Ugg. What's Ugg? I don't know what Ugg is. So I don't know. Anyways, thank you for the super chat and another happy birthday to Jedi. Okay, let's move on. I think Judge Simmons is next. Judge Simmons.
State of Michigan versus Corey Smith, 25-01207. Appearance, please.
Thank you, Your Honor. Gabrielle is here. Good morning, Your Honor. Assistant Public Defender Aaron Schroeder, on behalf of Mr. Smith, is present, stands to my right. And I'm handling this for Miss Attorney of Record, Stephen.
It was the date that was scheduled for sentencing. I don't have a report.
That's correct, Your Honor.
Why not? But why didn't you report to probation?
Was it Camp Anawana? I remember Camp Anawana. We hold you in our hearts, and when we think about you, makes me want to fart. Yeah.
I had missed my first one. When I rescheduled it, I couldn't figure out how to do it. I was wondering if it's possible to do it in person. I can go somewhere.
You're so right, because you're getting remanded, and that's how it's going to be possible. You don't come to over a month later and said you couldn't figure it out.
No.
He's remanded in custody until his pre-sentence report is completed. Give very clear instructions. You need to meet with probation prior to today so that they can get the report done. And for you to have an appointment, it says that you were scheduled for appointment on the 14th of July. We set these sentencings out 6 weeks out for the purposes of you meeting with probation.
No, I understand.
Not for you to come in here the day of and ask for another appointment in person. You should have taken care of that long before now. You could have called Mr. Milks long before now for help. You could have called probation long before now for help. You could have called the court long before now for help.
I have one.
Who did you call? You called the court and said, I missed my meeting. I need to reschedule it.
I called my attorney.
Well,
Did you call probation? Because your appointment was with probation.
I did.
And you rescheduled?
I attended.
You attempted?
He left a note he left a note on my case. I did. I spoke to the
It says the pre-sentence interview was scheduled for the 14th via Zoom, to which you failed to appear. The officer then mailed you a letter requesting a call to reschedule. which you did, and you were scheduled for the 25th at 3 p.m. Once again, you failed to appear. So you failed to appear twice. Yes.
If I do have an email from Mr. Neves that he sent to both, he forwarded to me yesterday, and he did send to Mr. Milks, and then he's not knowing Mr. Milks was out on paternity leave at the time. He indicated in that email that Mr. Smith had been reaching out to him to try to get things set up, but they just simply, there wasn't enough time to get it rescheduled again.
That's after missing twice.
I understand, Your Honor.
Yeah, you can't reschedule right before your sentencing. He had no business missing in the first 2 times in the first place. Anything else?
I will say, Your Honor, he did complete a substance abuse assessment. I did see the receipts from that with reality counseling.
Okay, well, he'll be remanded until he can have his in-person meeting with probation.
Is that like a 30-day?
No, as soon as Mr. Neves can meet with you, we'll let him know you're in custody.
Thank you.
Oh, wait, can you bring him right back?
Yes.
Got another bench warrant.
The dogs.
Yes, please, I need a referral. Yep, you also have a bench warrant on file number 23-00421. For failure to appear, that's for the unlicensed dog. You failed to appear on this case 1, 2, 3, 4 times.
I don't have access to the dogs anymore. They're part
What
of the
does that
state.
got to do with you coming to court?
No.
The fact that I had to put over a year ago, twice, remand you to get you here on a dog case is ridiculous. Actually, it was 1, 2, 3, 4, 5 times you failed to appear on a dog case.
I haven't owned the dogs.
That has nothing to do with you coming to a court date. You have ordered to appear in court, you're supposed to appear in court. You're ordered to appear before probation, you're supposed to appear before probation. So I don't care anything about an email where you tried to figure it out the day before. Get to where you're supposed to get to when you're supposed to be there and stop wasting the court's time. This matter will be reset for a pretrial. I'm not giving you a PR bond on the unlicensed dog because you don't come. You're gonna have to pay $100 to get out.
Yes, ma'am.
I could have a pretrial date for the unlicensed dog.
One more. Did you have something?
Just for the unlicensed dog, I need a new pretrial.
October 6th.
That's the next pretrial date? Oh.
Try again. Maybe it's
I
not.
mean, it could be.
I may have done that wrong.
September must be all booked up.
It's still popped up for October 6th.
That's fine. October 6th at what time?
10?
October 6th at 10 a.m. for that. And then we'll get a new referral down to probation so that Mr. Neves can meet with you. Once he meets with you, he'll notify me and I will adjust your bond at that time, okay?
Yes, ma'am.
You're all set.
All right. All right. That was a nice little short one. Judge Simmons, yeah, never get on her bad side. Not showing up for court for a year and then failing to follow court orders. Yeah, I mean, yeah, he's going to spend a couple days in jail. He'll be out in a couple days, though. All right. Moving on. What do we have next? I don't remember. I love how I always ask you guys what we have next. Oh, Judge Clark. Okay. This is a follow-up. Some of you guys remember this defendant. He's the one who got shot in the face. You know how we know he got shot in the face? He told us 10 times that he got shot in the face. He's claiming that all these charges happened after he got shot in the face and he's innocent, something like that. I don't know, but let's go.
I come before you is Anthony Taylor in 3 case numbers, 25-976, 25-1290, and 25-1295. In this matter, Your Honor, the state has tendered an offer and to have Mr. Taylor plead to 25-976 and consolidate the remaining 2 cases. At this time, he's declining that offer, and I believe we are ready for trial. And I think it's the state, I don't want to speak out of turn, the state's intent to go forward with 25-976. Is that right? The drug and lording and prowling case.
Are they dismissing the other cases?
No.
Not? Okay. Your Honor, when you're done reading, may I have a moment to ask you a question?
Hold on just a second. Yes, sir. Hold on. Let Mr. Pereira,
in the plea offer, that was.
Yeah, the plea offer has them dismiss the other 2
Plea
cases,
offer has
but
the
you
other-
said you don't
Well,
want.
I'm not guilty of either one. I don't know why my lawyer doesn't file the motion to dismiss. I filed for a Nelson and Ferretti hearing, but I didn't fit the 3-prong blanding test. So I resubmitted it Sunday night. I got the letter back from you, Mr. Clark, where it said that I didn't get the 3-part blanding test. You weren't here at the last court date. It was Mr. Grammer. But I explained to the court that I had been shot in my face and I was seeking medical attention. My lawyer has made he says that he made a small attempt through his investigator to get the video footage. There's 5 establishments that are in the area, like the parking lot where I got shot in my face. But for some reason, he sent his investigator to a totally different establishment 3 blocks away from where I got shot in my face. I also tried to get my attorney to go to Mr. Ferrer or Mr. Sullivan and inform them that I was able to get a firearm that they're looking for, but he can't even, for some reason, can't get the information from me to the state's attorney to give them this firearm that's involved in shooting me in the face and a double homicide on the beach that they don't possess in a 2 second-degree murder case.
They may not be interested in it.
Yes, it's very complicated thing. That's why I was trying to get either Mr. Sullivan or Mr. Ferrer a letter. I actually had one of my people take a picture of the firearm. So I got a picture over here of your murder weapon in your double homicide case that shot me in my face that you can't seem to get the.
they may not care.
They probably don't. That's how.
Just so the record, I spoke with Mr. Ferrer. He has the letter. They did some preliminary investigations. I don't want to, again, speak out of turn for the state, but they didn't find anything that they seemed to have found interesting. Then I talked to Mr. Sullivan about the case because Mr. Ferrer said it's not mine. Mr. Sullivan said it's not mine either. Let's talk to Mr. Graham. I haven't had a chance to talk to Mr. Graham. I don't know if he's going to go out and talk to Mr. Taylor or not. So I've followed up on all of the things that Mr. Taylor would like me to follow up on.
No, sir, he has not.
And I think I did get a Ferreira letter, kind of a letter asking for a hearing. I don't know what the court has done with that.
I don't have all the last thing in the file is an order dismissing it. What I'll do is
You dismissed my Nelson and Ferreira hearing because I didn't fit the 3-prong.
You filed another one, but there's not in the file yet. That's what you said. You filed one Sunday night.
Yes, sir.
It's not in the file yet. I don't have it. So what I'm going to do is, y'all want to set this for a trial?
Yes, Your Honor.
We'll set it for, what do you want to set it for, November?
As soon as possible, Your Honor.
November 3rd at 8:30. We'll set it for September 19th. That will be for the Beretta motion, any other motions, and for a trial management. Okay? Hopefully we'll have that paperwork by then.
I have a question, Your Honor. Is there any possibility, since how it's been in excess of about 4 months now, I don't want the exculpatory evidence of the video footage of me getting shot in my face minutes before I caught this charge for trying to plug my phone in. I don't want that evidence to be no longer obtainable, the video loop or the reel. And I can't get anything done pro se because I'm being represented by him. So is there a possibility that I could represent myself and not?
Is that what you want to do?
Yes, sir, because
All right, if you'll swear Mr. Taylor in, please.
Sir?
For the testimony you're about to give, some truth, the whole truth, but the truth, so help you God.
Yes, ma'am.
All right, sir, you can lower your hand and state your name.
Anthony Taylor.
Mr. Taylor, you've made a request to represent yourself. Is that correct?
Yes, sir.
Is that what you like to do, is discharge Mr. Wilson and represent yourself?
Yes, sir.
Okay. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in pretrial motions.
Yes, sir.
And also to prepare for trial.
Yes, sir.
And you wish to waive all that and represent yourself.
Yes, sir.
How far did you get in school?
6th grade, sir.
Can you read and write?
Yes, sir.
What do you do for a living?
I don't really do anything, Your Honor. I've spent the vast majority of my life in the prison system, and every time that I get out and I do get a job, it's normally construction.
Have you ever represented yourself before?
No, sir.
Are you under the influence of any drugs or alcohol today, which would impair your ability to make this decision?
No, sir.
Have you ever been
Just the painkillers from getting shot in the face?
Diagnosed with a mental illness that would hamper your ability to make this decision?
I've been diagnosed with mental illnesses. I've been involuntarily remanded to Florida State Hospital on several occasions. My lawyer right here beside the attorney that's standing beside me knows that I've had an extensive issues with that, but he hasn't asked me, hey, are you on your medication? That's another reason that he's very ineffective. He hasn't got the exculpatory evidence that would exonerate me of the 2 charges. He keeps trying to get me to take the statutory maximum of a 3rd-degree felony. He's like, take the 60 months. It's in your best interest. It's a 3rd-degree felony. Well, I think I would rather go to trial and lose and get the 60 months.
Okay.
I think, you know what I mean? But no, sir, I'm not on any medications. And
do you think that's affecting your ability to make this decision to represent yourself?
No, sir, but I do think that I need to be medicated, but the Bay County Jail will not provide the proper medications for me.
But do you think that since you've indicated that you're not on your medication, would that hamper your ability to effectively represent yourself?
No, sir.
I'm going to find that you're competent to represent yourself. We'll set this leave it on that trial docket, keep it on that September. I need to set it for September 19th at 9 o'clock. That's for the any kind of motions or anything that you might have them. We'll leave Mr. Wilson as backup counsel. Anytime that you'd like to have an attorney to represent you, one can be appointed to represent you. All you have to do is ask. Okay.
So now that I'm representing myself, will I be able to file? I don't want my motions to be null and void. But now
you're representing yourself. Whatever motions you file, we'll listen to. And I've got it set for a motion date.
Fast and speedy trial.
September 9th. September 9th. Mr. Wilson?
All right. So between the first appearance and that appearance, I think he told us that he got shot in the face at least 37 times. At least. But yeah, that was exactly how the first hearing went. He said it so many times. It's at the end of every sentence. But I got shot in the face. Yeah, but I got shot in the face. I got shot in the face. You know, like I don't know what happened, but he seems okay. Hopefully he doesn't have any long-term damage if that actually happened. I'm not saying it did or it didn't. I don't know. But he thinks it did, and I guess that's important. All right, moving on to the last case. Let's go. Judge Holmes, we got a weird eviction case. You'll see why.
We're here for 251076. That's right. We saved the best for last.
The funnest one for last. Yes.
All right. Well,
I have to give you those fun ones. Haven't you seen that yet?
This is Circle S Apartments versus Destiny Susan Green and other occupants. On behalf of Circle S, I have Mr. Daves here as counsel along with his witnesses. Do we have anyone at all on behalf of Susan Green? No. All right, Mr. Daves, tell me why this one is sought.
Yes, Your Honor. This is forcible detainer based on various non-rent related breaches of the lease. The evidence will show the defendant had breached the lease by storing items in a closet containing gas appliances, tampering with a gas heater appliance in the storage closet, damaging multiple appliances and light fixtures, creating dangerous conditions as wires hanging out of different fixtures there in the property. The defendant also introduced or allowed occupants not on the lease into the unit to live there, which is a violation of the terms of the lease. There's been damage to the entry door of the apartment. It's been kicked in multiple times. I'm sorry, Your Honor?
I'm looking at the photos. The first one is of the door. I mean, yeah.
Yeah, kind of a problem, which interferes with their business activities in addition to being damaged. All of these fall under paragraphs 10.3 and 11 E, and F of the lease. The evidence will also show that a notice to vacate was given in accordance with the lease, and that notice to vacate was issued on July 22nd. They were given until July 27th. The CARES Act is not applicable here in this case. We're not asking for rent. We're seeking possession of the property and attorney's fees.
How much are you seeking for attorney's fees?
In connection with this matter, Your Honor, I've had emails back and forth with my client. I've reviewed documents provided by my client. I've drafted documents relating to the matter, including the notice to vacate and the petition, calls to and from the client. I've prepared for this.
Oh, don't worry. We get to see a lot of them. I don't think we get to see all of them, but we get to see some of them. And yeah, they got sounds like they had some squatters that totally ripped the place apart for copper wiring. That's what it sounds like, and that's what the picture looks like. I could be wrong, but yeah, that's what it sounds like to me and looks like. Now I'm repeating myself. Let's go. Sorry.
Hearing, examination, prep, exhibit compilation, review. I've incurred the time and attendance here today. All total up till right now, I just recalculated 5.4 hours. My hourly rate is $300 an hour, which amounts to $1,620. I've been practicing since 1989, and I believe the time and charges are usual and customary for handling this type of proceeding.
I agree with all of that, Mr. Daves. Thank you. All right, and the monthly rent under the lease was $1,560, just so I'm getting a sense for the appeal times. There's no
Yes, Your Honor.
subsidy in that?
Correct.
Okay. Let me just share with the parties what we did receive. So first, we did receive back the return for the defendant.
All right. Just for the real quick, they're gonna throw an address up here, so hopefully this covers it. Where is it at? All right. Just for the first slide, I'm gonna put this up
Thank
here.
you.
Here is that return for cause 251076 for Destiny Green, returned by Deputy Steele. They did affected alternate service. So she's aware of it. And then as part of the proof, as an offer of proof, you've submitted a series of.
Okay. That's it. Now we can watch the pictures. Here we go. All right.
Photos in advance. And Mr. Daves, is it your testimony today, and do your witnesses testify that these are accurate photos of the premises?
Yes, Your Honor.
Okay, and I do take note of the damage immediately to the door. I see the plates are missing.
for
This
all
was where the
that we
lights
did.
used to be, huh?
This is all we can get to upload it one.
All right. I'm gonna do this to try to make it a little bit better. See if I go here, makes it a little bit bigger.
Time that's even more extensive than that. Every outlet in there has been tampered with. Every appliance has been stripped of its electrical. Every smoke alarm has been taken down, so it's become a fire safety thing. So that's why it has become we had to do this because at this point they pose a risk to other people in the building.
Yeah. All right then.
Your Honor, we also enclosed Claims Exhibit 4, which are copies of the violations that lay out the details of what had been going on.
Oh, I see that.
And of course, with natural gas running to a building, anytime you tamper with electricity, that's kind of a big one for me.
Just a spark. We've had recent. I mean, just
It's
last month.
yeah, I take their safety very seriously. So as soon as I saw that, my heart stopped for a moment. Especially when I saw the smoke detectors were all missing on top of it all.
Just the first one, tampering with the gas water heater, got me. I mean, I'm immediately
Yes.
listening. Then I see the photos of the rest, and I go, "Yeah, that's you're
Huge,
there.
yeah,
They're
very
there.
huge. And we have elderly disabled in that building, like wheelchair and deaf. That it just stopped my heart.
All right. It definitely is going to be a judgment for the plaintiff due to multiple lease violations. We would find not only possession, we would award attorney's fees, Mr. Daves, at $1,620 for your time and effort in the court case. For appeal, I have two thoughts on this one. I definitely would put it for at least a month. I'm happy to double it if you think that is a reasonable thing.
Can we request to double just because of the severity and the nature of this one? Of the extent of the damages and the risks of residents that if they do appeal that we would like to request it be doubled for that reason alone.
Mr. Daves?
I defer to Ms. Jackson on that. I would agree. I think maybe that would be helpful in ensuring that we don't have issues.
Okay. Court will accept that recommendation. I think that's reasonable given what I've heard and the photos and things. So it's judgment for the plaintiff with possession, court cost, and attorney's fees of $1,620. Either party can appeal the decision. The appeal bond is set at twice the monthly rent, so the appeal bond is $3,120. All right, good luck. All parties are excused. Well, Mr. Daves, we did save the best for the last, and you're right. Normally we go through these and it's all non-payment, and today we had some.
Thank you so much.
All right. All right. That's it. That's all I got. I told you it was going to be a shorter live tonight. I got to get to bed. I'm going to be up early, and I will be documenting this trip. So you guys can, you know, I don't know if I'm going to post it on the channel or just post it on Discord. So if you guys want to follow along on my little road trip, then jump on Discord, and I'll be posting things tomorrow and Saturday, and then obviously while I'm actually in Nova Scotia. But yeah, everybody, thank you so much. Again, I will not be on tomorrow night. I do have a video ready to be released tomorrow, but no tomorrow night, and Saturday is already my day off, so I will not see you again till Sunday. I should be live Sunday night. No promises, but I should be back Sunday night. All right. Yeah. You guys have a great and safe weekend. If I don't see you, yeah, the next time I talk to you, I'm going to be in Canada. Whoop, whoop. All right. You guys have a great night, and I guess I should look to see if I should. Yeah, it's early. I don't know if I'll be able to rate anybody, but I can look. Hold on. I am not in the right screen. All right, here we go. No, I don't have anyone live. Oh, this is last night. Hold on. Was that last night? Looked like the exact same channels. Okay, here we go. Oh, Credence and Mikey are on. Credence and Mikey After Dark. We'll go check out Credence and Mikey. All right. You guys have a great rest of your night. We're going to hang out with Credence and Mikey. All right. That's it. That's all I got. Till next time. Bye.
Your Honor.
Thank you all very much.